without being touched, hopefully the trip.
All right, we're going to go ahead and get started. Welcome to everyone for coming, and welcome to those of you who are watching on the Facebook live stream as well. Anything more?
Yeah, you're good.
I think this is the 6th year. My name is Pat Cooper. I'm the president of the Omaha Bar Association. This is the 6th year that we've done a year-in CLE, and at some point we realized we weren't doing anything at the end of the year when everyone needed some credit. So we started this one to benefit the lawyer referral service. And you may have seen Donna Berkby in the back of the room when you checked in. Donna has been the director of the LRS program here for almost 30 years now. The proceeds from this CLE will benefit the LRS program. And so if any of you are interested in learning more about what the LRS program is all about, please see Donna at the break or after the program, and she can fill you in. She has become a pro in referring cases out to lawyers in this area. So thanks, Donna, for all that you do. We have a great panel of 6 speakers today, each going to talk for about 20 minutes. So I want to thank all of them for their willingness to share their time and talent this afternoon. I think we have, if you need more CLE, we have some on-demand options available. Dave has been taping all of these CLEs we've been doing on Facebook. You can access those on Facebook and get credit. So talk to Dave if you want to learn more about that as well. And so with that, I'll turn it over to Dave, and he will introduce our first speaker.
Thanks, Patrick. Thanks, everybody, for showing up on a still cold Friday. We're doing this a little bit earlier. Try to keep it moving, 20 minutes each one, and try to get you out of here by 4 o'clock, so hopefully that works for y'all. My name is Dave Summers, Executive Director of the Omaha Bar Association, and I'm very excited to have what I hope is a couple innovation CLEs to come. But this first one, really setting the groundwork for some different types of practicing out there, some new ways of looking at what we've done for a very long time. And the first presenter here today is Patino of Koenig Dunne. And Patrick is primarily a bankruptcy attorney. And as we were talking a while back, when Patrick's presented other CLEs we've done, he was talking about how the practice has really changed, how technology has taken a big role in that practice. And I thought, well, a better way to kick off a couple hours about talking about embracing innovation by talking to somebody who's actually doing it already in the practice. So I'll turn it over to Patrick.
So, one from my slide.
Oh, yeah.
Bring it a little close.
So, here we are in the year 2018, in a talk around technology in the law practice, jettisoned straight to, oh my gosh, robots and AI are going to take all of our jobs. We are not going to need attorneys because we're going to have little Alexas and Docs and Echoes and what have you, being able to intake all this data, all this information, and search through indexes and spit out legal advice. But we're not there yet, and many of us practice in small, solo, medium-sized firms where access to that kind of technology is way too expensive and probably years and years away. However, we do have today, how many people have ever taken an Uber? Raise your hand. Wow. How many people for Christmas have ordered something on Amazon on their phone? A lot. So we have a situation where we have these things out there that clients or customers are coming to expect. I mean, you can order a Domino's pizza and track the delivery of it on your Apple Watch. And then they're coming to our law firms, and they're like, well, how kind of want to do that here. And you're like, well, you can't. And it's jarring. They're like, I can order a pizza, but I can't do this here. You're supposed to be more sophisticated than Domino's, and a lot of us aren't. And so as we have the millennials, the scary millennials like me, coming out of law school and becoming consumers, this is going to be the expectation. And it provides, ease, efficiency, and value. So we're really going to need this embrace of technology and tools in the practice of law to meet client expectations and to fulfill our professional responsibility to kind of know what's going on. So in the practice of bankruptcy, we have my father-in-law, Howard Duncan. He's been practicing for about 40 years. I joined his practice straight out of law school about 4 years ago. And Howard, don't kill me, but when I joined Howard, he didn't know what he was getting himself into by saying I could come join him. He loves paper, still does, and that's okay. How many people love printing things? I'm sure there's more that aren't raising their hand, but Howard loves paper, and that's okay. But as time goes on in the practice of bankruptcy, you have information, a lot of information coming in. Sometimes now it's hundreds of pages of bank statements and pay stubs, and you need that information to be the most up-to-date in order to file a bankruptcy. Well, the turnaround time before could take 3 or 4 months. That's a long time. It's a lot of wasted energy. You end up drafting bankruptcy paperwork more than once. So we have built in the use of technology and tools and really leveraging kind of that everyone has a smartphone to our advantage. So, Dave.
Oh.
So technology and the ability to create tools is becoming, you want to pause that real quick? Oh, that's fine. It's becoming cheaper and more accessible. So this is something I created in about 15 minutes to obtain a client's driver's license. This didn't take any coding. This didn't take me having a computer science background. I just strung together a couple of different products available online, all free, to take something that traditionally someone would have to come to your office, bring you their photo ID, you'd have to have someone scan it, and that takes time. People don't have time. They don't want to do that. They don't want to take off work. They want to be able to, from the comfort of their house or work, pull out their wallet, pull out their phone, and take a picture. And this automatically would get sent to me, or to a secretary, or to whoever, and is in the cloud. Whoever would need this, let's say it was someone covering a court hearing for you, needs to see what the client looks like, would be able to just pull out their phone, say, oh, that's John Smith, and boom. So in the time that took, which was about a minute and a half, you couldn't even get someone to get in their car and even get it to start being born. So you can go to the next slide. So this is available now, and this is going to be more pervasive and more prevalent. You can do it. This is not hard. Like I say here, technology is your friend. I know as attorneys we're hesitant to change, the courts are hesitant to change, but in the bankruptcy practice, we've actually gone through kind of this embrace where, as far as I know, the first bankruptcy jurisdiction in the country that allows clients to provide digital signatures for things filed in court. That's a game changer. We don't need wet ink anymore. We don't need any of that stuff. I can, from my phone, send them a document, and Howard can attest to this. We went from maybe a week turnaround time, the fastest someone's ever gotten something back to me is less than
I'm not quite sure why. Sorry. Technology is your friend.
Maybe not.
Full screen.
Okay. So, bankruptcy, like a lot of other practice areas, and with the dawn of technology, there's more and more data. So, one of the things is technology has created this boom of data. I mean, in a family law case, I'm going to digress a little bit. You know, you have a discovery you want to see from this text messages. Oh my gosh, that could be a ton of data, and you need the client to be able to provide that to you. So in a kind of a traditional timeline, you would have it be very manual, even if you're using paper or email or review. A lot of this requires a human to do something, to push a button, to send an email, to forward that email, to print something off and put it on someone's desk. That takes a lot of time. And in that, you lose out on having enough time to talk to the client. How many people wish they had more time to pick up the phone and call the client? That one person. One person. I don't believe that for a second. How many people think that more of their problems would be fixed faster if they could get on the phone as opposed to sending an email? That few. Well, there's this law practice management software called Clio, and they do a legal trend review. And lo and behold, your client actually wants to hear from you on the phone. It's actually one of the largest disconnects. Many attorneys think the client doesn't actually want to hear from me. They're fine with email. Many clients, even young clients, want you to pick up the phone. Well, this timeline doesn't allow much space for that to happen. You think you're doing a good job, you're sending emails to the client, they're not satisfied. They want to be able to, at midnight, pick up their phone and see what trial is. They want that immediate thing, and they want to be able to talk to you about something that's real. So now it comes in, and then there's a sad face, because a month to do a bankruptcy, this would be a very fast bankruptcy in a traditional sense. Well, now, I think you could probably do a bankruptcy in a day. Realistically, in a day. Where you leverage the client to help you input the data. So you can create web forms out the wazoo, like I did, and collect all kinds of data. It can be dynamic, there can be logic built in, you can have them sign things, pay for things, provide documentation, all of it. And then the process that they would follow, a lot of it's automated. So the client would fill out a questionnaire that would auto-populate all the standard documents. The attorney could review that all online, hit approved. It all goes to the client online. The client can review it. You can hold a video conference. Boom, ready to file. Ready to sign, all done. No paper created. Now, this process, some people are doing this now, but this is what's coming because there's going to be an expectation that it gets easier. People don't want the process to be hard because they're going to start comparing. Like I started with, they compare to, hey, I can hail a cab, an Uber, I can watch it coming to me, but when it comes to my legal process, I'm in the dark. There's no timeline, I can't see where this thing is, I'm having to follow up all the time. Wouldn't it be a lot easier for me to have to do that? So, who wins when we go, or are going to this model where technology allows the client to have buy-in, the attorney to do things with more ease? Well, your clients win, because they're probably not going to be spending as much money in that smaller timeline, but are still getting the same, if not better, value. The firm wins. So instead of having to hire another person, you can automate that person's job. Howard, when I started with him, we had 3 support staff people. Because of technology, we went down to 1. lastly is kind of a call to action. Here in Nebraska, particularly with our bankruptcy practice and other practice areas, the statewide is aging. Everyone's talking about this. There are counties that there's no attorneys or few attorneys, and how are we going to provide adequate legal services to people out in the community? And it's going to be through technology. It's going to be how do we build these systems that are affordable and upfront to be able to help Nebraskans at large. So that's it. I made it under 20 minutes.
Yeah.
So I guess this is my contact information. If you have any questions about technology and integrating it into your practice, you can email me or call me, and I'll be really happy to talk about it. Thank you.
Everybody, I want to introduce the next speaker, and also I want to try to move this speaker over to that side if I can for the Facebook people to hear a little bit better, because I think it's maybe echoing a bit, so I'm going to shift a little bit, but I do want to, well, I want this speaker actually, so if we can take a 2-minute break while I check a little bit over. You start, then I'm going to talk radio, sorry. I just want to see. You know what?
I'm distracted.
Maybe hold it this.
Just increase the volume. See, normally, no, I don't even need a mic, Dave, but I just had sinus surgery, so I'm a little worried I'm going to end up with Justin Timberlake instead of making it 20 minutes today. Good? All right, so I'm actually kind of cheating and putting all my favorite topics, which is anything technology, into 20 minutes on alternative fees. So the thing about alternative fees, do I have to point it there? Yeah, so what is it? And I think it was actually when I was talking to Dave, a lot of people think alternative fees means flat fees. I rarely use a flat fee. I wouldn't really know how. So that's one of the things is to know that alternative fees mean a lot more than just like, if I quoted somebody having to do $7,500 for a estate plan, they might walk out. But instead, I break down the process and quote fees that way. But every time I give this presentation, I learn about all kinds of flat fees because they're very specific to practice area. And so there's a whole bunch, and I don't have time to explain these, but I did give Dave a more detailed outline. I give this presentation quite often. So, but if you want, I'm also more interested if you have a different way of charging that I don't know about, because particularly litigation is not my skill set. I see Eric's here in the room today, and we used to work together and we used to have conversations about, well, litigation is a process, so you actually can figure out how to break down the process and charge fees. But those are some of the ways to charge the different alternative fees. And then one of the things is what gets in the way of using alternative fees. It's easier to say I charge $200 an hour than it is to say, hey, this is going to cost you $25,000. But what the client really wants to know is that it's going to cost them $25,000. And I had a business client early in my career who said to me, Mary, the deal is I'm a business person. This business person was giving me a chance at this project that I had never done before. I was taking the client into every province in Canada. I didn't know how to do that. I think I was like 3 years out. I'm like, I don't know anything. Why are you letting me do that? I have no idea how to tell you how much it's going to cost. And they said to me, we will give you this job, but you have to tell us how much it's going to cost. So I sat down and figured out, okay, there's going to be a process. We're going to have to go into each plan. And ever since then, what I remember is that thing one is people really do want to know how much it's cost. When I go have some work done at the dentist, I don't know how much it's going to cost. So we need to be able to learn to have conversations. I think sometimes there's two things I see people do with alternative fees. Then they underquote. And then if you underquote and you get to where you've used up hours times your time, then you don't want to really work on it anymore. But we underquote because we're afraid to say how much we're going to actually charge. But then we're kind of doing both of ourselves a disservice. So you just have to get really good at quoting alternative fees, and I'll give you some ideas on that. But the other thing for me is why do you want to do alternative fees? I just want to make more money faster. I I'm really good at technology, I'm really efficient, and I can draft a really complex trust in 27 minutes because I've automated every piece of the process. And so I never charge like for document preparation because I would make no money. I charge for what I think my clients value, which is, I've been doing this for long enough. I was thinking, Patrick was talking, I'm actually practicing long enough that I remember the old typewriters that weren't even electronic. And so when you talk about technology, I'm like, yeah, we're all still here today. We all still have jobs, but hopefully nobody in here is using one of those kind of typewriters or has it in the office. I did find out that my staff was hiding one from me, and so I took it and I threw it out. They were trying to use it for stock certificates or something like that. But anyway, so the important thing in alternative fees is knowing what clients value. That is different for every practice area, right? But there's certain basics that I think matter for almost every type of legal work that we do. And it's one that I put a price on. And that's called so I do a lot of trust and estate work, I do a lot of business planning, that type of stuff. When somebody comes in, especially if they're new or it's just a new project, the first piece is you have to talk to them about what the project is, find out the information that you need to figure out what they need to make recommendations. So no matter what project we're doing, I put a fee on intake, analysis, and recommendations. Because that is the most time-consuming piece of my process, and I break it out. Let's say I'm doing an estate plan. Somebody doesn't follow up, I give them an engagement letter, and that engagement says, hey, we're going to bill you for the intake, analysis, and recommendations that we do. And then once you decide which documents you want, we'll give you a quote for that, and we'll give you a quote for the other pieces of the process, right? So we don't necessarily, can't quote the whole project, we don't always know the direction. That's why you hear about litigation, you never know what's going to happen there, right? But it's the same thing true. It's one estate plan is not equal to every other estate plan. What clients need is different. So whatever practice area is about figuring out, hey, what do my clients value from me? And there's just some suggestions. It might be avoiding risk. Some clients, we do a lot of what we call just routine work. We take care of stuff that our clients could do, but they don't want to do it. So it's easy by annual reports or annual consents or things like that. It's stuff that they know will be taken care of because you're going to do it. Areas of specialized knowledge or experience, I do some geeky tax stuff. That's one of my specialized knowledge areas, but almost everybody in the room probably has some specialized areas. I always tell my lawyers at my firm, I always talk about, what do we want to market this year? And some, oh, real estate. I go, what does that mean? What does that mean, Dan, right? Okay, what kind of real estate work do you do? Talk about, you look at your LinkedIn profile, do you put real estate lawyer or trust and estate lawyer or litigator? Sell yourself a little bit with what you do, really find that specialized experience. Confidence, timely turnaround, that's a big thing. Communication, that's still, I have a former judge working for me who every day walks around and reminds us that communication is never what causes malpractice, but communicating with your clients keeps them happy. And communicating about costs and options, right? It's just, I have a really easy time talking to people about their options and what it's going to cost, because I just did, I realized, and I have people say to me all the time, well, it's not really always that easy for lawyers because we have different personalities, but I think it's one of the most important things to learn. The last thing I want to do is send a bill at the end of the month and have a client call me up and say, hey, if I'd have known it was going to cost that much, I wouldn't have hired you. I could have been out golfing or something like that instead. So I don't know why I killed myself to do your project when you didn't want to pay it. But had I told the client what it was going to cost and what was going to be involved, I would have never got that phone call. And I can tell you that I never get that phone call. So one of the other things is if you don't have particular values, just seek ways to go ahead and increase your value. And again, communicate about what it is. So the other thing then, so I just break this down into steps, is to know the legal industry. So like Patrick alluded to, there is change, there's always change, that's part of every day, right? And there's a couple places where there's really great research. It varies by practice area. The way consumers want to buy service these days, it varies. So business consumers are buying differently than individual consumers. Some of them still want the personal phone call. There's some differences in different types of consumers, different age groups of consumers, genders of consumers, all kinds of things. There's some great research out there. Stanford has a great research. But pay attention to the research, and that's one of the things that we do. What forces impact legal business? There's a lot of vendors out there. Oh yeah, your profession's going to be taken over by AI. No, it's not. I'm going to use that to help myself make more money and improve my alternative fee structure. So, but do know your business, and then be clear about what your business is, not just the industry, but what is your business? And that goes to the question I was saying before: is hey, I'm a tax lawyer. Well, what does that mean? And people think I do individual income taxes. I don't really know very much about that at all. So it's, what exactly do you do very specifically? Because to price your product or your service, because there's some of both, you really need to understand what am I providing. And it's a really interesting thing that I will tell you that I have conversations with lawyers about this all the time. What exactly do you do? I do the list, the list. Well, what do you do? And so it's a hard thing to sit down and say, okay, what is my business? And for my business, and every time I ask me, so, I don't say, hey, this is the alternative fee for everybody, because I know that the alternative fee that works for your practice is practice specific. And then make data-driven business decisions. This is one of the best things about technology. There's big data, there's little data. I'm not going to get into the fine details of that, but do use data. So I will tell you, I don't love Clio, because I think they make some of their stuff up. But especially they say, okay, the average attorney only bills like 1.8 hours per day. Isn't that what they're studying? Something like that? I'm like, okay, come on. None of us would be here today. But anyway, they've done some really good stuff in terms of their product. But using data, you don't have to be a total data expert, but you can use some simple ones. One of my favorite simple examples is somebody said to me about referral sources. That like we get kind of in these emotional things, and we think that person X is referring us business, but when we actually track the data, we find this all of the time. And we send a Christmas gift to, person X, and we ignore person Y, well, like we're idiots. So, we like use data. Same thing with the billing data to figure out where you can use alternative fees. We, in our billing system, so let's say, again, I do a lot of estate planning, but I can break it down, and I can tell you how much time was consumed the last, 100 and some times that I did an estate plan for a single person with minor children or thing. I can break it down by almost every category, tell you exactly how much time it took, how much it cost us, and what I charged. And that's how we make our pricing decisions, so we use data. And that's really easy, because I don't know a billing system. Oh, wait a minute. I met a guy in California recently who was actually still writing his time in a Word document. And so that billing system might not track data. But if you're using Clio, or using tabs, or using any of those billing systems, you can break down categories of billing and just do that one step, and it'll help you so that you know, are you actually making or losing money on a certain type of practice area? So we look at it every year and say, we're going to keep this practice area? No, we're like losing our butt on it, so let's get rid of it. Let's do the ones that are profitable. Unless they're loss leaders, which is another difference. So there's a whole lot of ways to use data. Develop a process-oriented, so Patrick alluded to that. So process means every legal project has a process. So if you haven't read the Checklist Manifesto, it's one of my favorite books. It says this is how you make a checklist. So people go buy technology, they'll spend tons, I hear this all the time. I went and bought this technology and it's not doing anything for me. Well, why did you buy it? Well, because the vendor said it was great. Like, well, what problem were you trying to solve when you bought that technology? It's, trying to, whatever. The answer is, so I always say, it's like, okay, thing one in figuring out how to do things is figure out what your process is. So, if you're forming an entity, because that's a really easy example, you got to do, you got to run a conflicts check. You got to make clear a name. You got to do, it's like A, B, C. So lay it on the document, I don't care if it's an old-fashioned Word document, but know what your process is before you try and automate it. So people go buy technology without understanding their process. So that's where the Checklist Manifesto, and it does a nice job of saying, make a checklist for everything, but don't overdo the checklist or underdo the checklist. So develop a process-oriented strategic plan. Have processes for everything, and then automate them. The other thing I like to talk about is knowledge management, and that is, it's really, really simple. So it's like, okay, have you ever written a memo, really complex memo, on some bizarre issue, and then you can't remember where you saved it 3 years later when the same issue comes up? Or you walk into another attorney's office at your firm, and I'm a small firm and this still happens, and they're researching something I just did a detailed memo on 2 months ago. I'm like, oh, seriously? Why don't you read the memo that we had on that? So I'm really big on knowledge management. I've created within a fairly simple document. You can get really complex by really expensive knowledge management systems. I just basically use a section of our document management system, and we created electronic bookshelves, and then we organize the bookshelves, and we keep all that information there so that people can access it. So you can find sample documents, you can find the outlines from this particular CLE this afternoon, or whatever the case might be. So that's like knowledge management, which is another way. So like if you're trying to make money on alternative fees, which was my goal, is one of the things is to have your knowledge managed, to have your processes documented, and then automated. So looking for opportunities to automate. So one day I realized that our incoming mail, we still had a lot of mail, and we've been paperless since 2005. I told Dave that I totally trusted him. I usually show up with my own computer and my own electronics. I said, Dave, I totally trust you. You're the only guy at seminar I ever speak at. But I did actually print one piece of paper just in case, right? But I don't print a whole lot of paper. And we've been paperless since '05. I love, my favorite story is having an associate come back who brought a file back from another firm, and he was looking at it going like, what is this thing, right? So, but even every little thing is we had still realized that we were paying somebody at our front desk to slit open mail envelopes and then to open that, and then we scan it in because we're paperless. We're like, wait, so it's one of those processes. We look at anything that's time-consuming, expensive, particularly staff. It's really hard to hire staff these days in Omaha, Nebraska. So my solution is just automate that because you can't hire them or you have to pay too much. So we came up with an idea in terms of let's figure out how to do more automation on our mail process. And we cut the volume of our incoming mail down by half within 6 months. We have very little mail come in these days, and so we don't actually have somebody that does that job, just gets split around. So anywhere that you can, look for ways to automate. It's not just about forms, and people do. I know some people. Does anybody still have paper files in here? No, wait, I don't want to know. Okay, so create systems and checklists. They also, in addition to creating the basis for automation, help you avoid malpractice. Have you ever had somebody forget to you do all the security interests and things, and somebody forgets to file something or something crazy like that. So we use checklists. There's a lot of transactions that are routine, so you can make a checklist for everything. My theory was I wanted a checklist. I'll just use the entity formation again because that's an easy one. That was so idiot-friendly because my mother said to me, if you can read, you can do anything. And so basically, it's like, oh, okay, so I learned how to read things, and she was right. If you can read, and it says do A, do B, do C, then you can do anything. So we try and create checklists that if we hire somebody totally new to the legal profession that's never spent a day in an office and has no idea what a legal document is, that if they follow our checklist, that they can actually do whatever it is that we ask. The form automation, hopefully nobody here would ever pull up some other client's document and use that, right? Nobody does that. If you do, please don't. Stop it. Learn how to automate your forms. There's a zillion ways to do it. I don't have time to talk about it right now. Step 8, use true cost. So this is the other thing I alluded to it in the data portion of the presence. But it's amazing to me, know your true cost, right? I was at a law firm where it's basically lawyers billed for their time, but they really didn't have an awareness of how many staff people they were using. So we don't have anybody in our office. There's a couple exceptions these days. But for the most part, if anybody is touching client work in any way, I don't care if it's ultimately we're going to build it into the fee, but we're going to track it. Because if I don't have any secretaries, I would know what to do with them. But, I know some people used to have those kind of people working for them, and they would have them, print documents or whatever they did and staple them and things like that. But then that's expensive. So if you have that, you need to know how much you're paying and how much time it's taking that person. So we tend to bill only for the attorney time or the paralegal time. Then you never know the true cost. How much is this actually costing me? And wow, how much paper? If you are using paper, that's part of the cost of your project. All the things that you pay for. So you gotta really, that's the data, track everything so you know your true cost. That's how you can make a profitable alternative fee. Your billing system, and I've already talked about that, so organize your data, know who you're billing. That's another one of the ways that we look at it is we think we're doing work type Z all the time. It's just like the referral source. So somehow we think we're a Z project lawyer, and then we look at the data and we're like, actually I only did project Z twice last year, but I did project A 200 times. So what should I focus on automating is probably project A. That's probably where I need to go. And so, so it's simple math, right? How much can you charge for the project? How much is it going to cost? That's your profit. And my goal is always to make a premium rate per hour. There are ethical issues related to that, right? You have to charge reasonable fees. And one time, I quoted a fee, and we came in 20%, we actually came in like 20% under what we found were reasonable fees being charged by others. And I had a court say to me, because we tracked our hours, which was just so we knew how much it cost, that we had to reduce our fee. And so that is evolving now, and we've changed how we approach that, so we don't necessarily track our time. I mean, I don't know how else you ultimately cost it, but so we have different time tracking methods for that. But it's really simple in terms of know how much it costs. Anyway, thanks so much for listening. Have a great day.
And I just want to say, the 20 minutes was a pretty short amount of time for all that Mary covered. If you want to hear the extended version, it's going to be on a podcast next week. We had the conversation a few months ago, and I've been sitting on it waiting for this CLE to be done, and then I'm going to release it. So you can look for that next week. And both Mary and our next speaker spoke a few years ago at the LRS CLE. We're happy to have them back. They have been leaders in the community and in the nation in embracing technology in their legal practice for decades now. Next is Dan Smith of Slusky, and he is going to talk about one of his favorite subjects, Microsoft 365.
Thank you. Yeah, I have one slide, 20 minutes, I think one slide's about right. The title of this shows some confusion in the Microsoft world right off the bat. There really is no such thing as Microsoft 365. Lawyer's Edition, this is Microsoft's fault, because they try to market these things with all kinds of names and create a huge amount of confusion. What I'm actually going to talk about is Office 365, which itself is two things. Thing one is a way of subscribing to all the Office applications, Microsoft Office applications. I'm less interested in that one than I am in the other one, which is this cloud-based ecosystem of applications and storage that Microsoft's been developing for a long time, and which has wonderful legal-specific uses, even though it is a bit of an erector site. Some assembly is required. I used to write for the Bar Association technology column, and I always say I have a lot of tools in technology. That's still true. I don't go to technology in the law biz for fun. There are those who do that. I'm cold-blooded about it. It has to deliver better service to my clients, more money to the bottom line, or make my life better, easier, or faster, or I don't want to know about it, I don't want to deal with it. However, especially for younger lawyers, I think you must make the effort to understand technology and apply it in practice. You must become a technology virtuoso. I wish it wasn't so, but it is so, because you're either going to be the slave or the master of technology, and there's no middle ground. So become the master, and this is going to take real work. Some of Mary's slides show us things like hot docs takes real work. Knowledge management takes real work. Word styles, which are incredibly powerful, takes real work. And you, the lawyer, should be the one that understands this. Or else have some wonderful IT person who's willing to do it for you, understands the law business, down to the bottom of what your day-to-day work looks like. So Office 365 is it's part of the Office application world. So Word, Excel, PowerPoint, all those things are delivered through Office 365, but the online subscription ecosystem is also part of Office 365. It's the core of Office 365. I have this periodic table of Office 365 to show you all the things that it does. The good news about it is it's a cloud system, so there's many good features there, and that it'll follow you everywhere. That's sort of the good news and the bad. It's going to follow you everywhere you are. It's going to be on your iPhone, iPad, Android, laptop, in your office. And the bad news is it's going to follow you everywhere, because it's, in the modern law practice, it's always good because you can't get away from it. To get away from it, you have to exercise a certain kind of discipline. It's built-in disaster recovery, because the data that you store on Office 365 is in 3 cities, in 3 hardened facilities. I've actually visited the one in Chicago at the invitation of Microsoft. Incredible, stunning places, and very, very secure. The data is also very, very secure. It's secure in transit, it's secure in rest. They go to a great deal of trouble to prove up to you and the big corporations how secure president of Microsoft can walk in and go on and walk on a search. You can't do it. There's a key that you have to have, and there's a key to the key that you have to have. You can only be in the room for 15 minutes. So they're very concerned about this because it's their lifeblood. They don't have a business if they start losing data. So this is a disaster recovery for you. Your office will burn down and your data is still going to be good. It's in Office 365 in the cloud. Another sort of good news, bad news thing is it's like Big Brother. It watches everything you do. It pays attention to everything you do. Now, so that's sort of a bad thing, I guess. The good thing is as an assistant in your practice, it's getting better and better. Office 365 is in constant change, constant improvement. There's bad news there too, because you've got to be learning all the time about these things. That's part of being a technology virtuoso. But, so for instance, just as an example, if I go work on something in my office, save a bunch of stuff to a certain location in Office 365 or SharePoint, and I'm sitting in my car waiting for a document that's happened to me just yesterday, a client calls me and says, I want to know the contents of this document you drafted for me. I said, okay, I'm looking at it. They say, wait a minute, I thought you were in the car. Yeah, well, I got an iPad. I punched the button on Office 365, and it said, I see you've been working in this area recently. Do you want to look at these documents? Yes, that's what I want to see. There's no document. It's up as a PDF. I'm talking about the contents. That's a useful thing, part of communication with clients, real communication on real phone calls, and then actually talking about substance, no matter where you are, very big deal, in my opinion. So let's talk on my slide here about the biggies in Office 365. Put black around some of the most important ones. There's lots of apps in Office 365, lots of productivity tools that are used for all kinds of reasons. We see, for instance, Dynamics 365, we see Sway, which is sort of a PowerPoint light sort of thing, or modern PowerPoint. And then we see the Office apps. I didn't put black on those, even though you're going to use them all day, every day, like Word online. You're going to use that all day, every day. But in Office 365, if you subscribe, you get an Exchange server. It's just built into Office 365, which will manage your calendar, your email, all the stuff that you're used to seeing in Exchange and in Outlook or the Outlook client on your desktop. And it's a fully functional Exchange server. It's more functional than the one you have in your server room. And at this point, it's very stable, it's very capable, and there is no reason at all not to use it. If you're going to subscribe to Office 365, just get it. And all this other stuff comes along for the ride. So things that we use continuously, OneNote. Every matter that we have actually lives at the site, and SharePoint, which I'll mention in a minute, and every one of them has a OneNote notebook. And again, OneNote will follow you everywhere. And in there can be trial notes, can be outlines, can be images, can be tables, graphs, copies of anything you can imagine, any structure that you care to feel extremely useful in the practice of law. And again, if you open up OneNote on your iPhone, it'll say, I see you've been looking at this particular OneNote file in your office. You want to open it here? Yes. Boom, you're there. That's the Big Brother aspect. So that's hugely important. SharePoint Online, I guess I'll mention now. SharePoint is its own world. It's a storage, it has storage capability, really of infinite capacity online. Some assembly required. You've got to decide how you're going to structure your data. Big firms are going to want to take a special approach so they can scale big time. Smaller firms can do it with a few sites and subsites and folders. And it's pretty easy to set up. It's pretty easy to do. Mary talked about knowledge management. We have a very big SharePoint storage facility in which there's many hundreds of thousands of documents. SharePoint indexes every word of every document every day. And if we set up our search in SharePoint, stated in SharePoint, to be legal specific, we don't lose anything. We find every paragraph and every memo going back 25 years. And if there's a certain phrase that I want to find and use today, one of my partners did 20 years ago, I'm going to find it. I'm going to find it now. And we built in these refiners into it, so you just go click, 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 and you go from 200,000 hits to 10,000 hits to 4 hits, just by hitting the super quick refiners. I want it to be a Word document. I want it to be within this font. I want it to be within this matter. I want it to have just these words, but not that word. Boom, you're there. So there's knowledge management for you. You never lose anything. Also, we set it up so that you can tag each of these documents, so you have further knowledge management. Wait a minute, if I run out of time.
No, you're good.
Also, Office 365. OneDrive for Business comes with it. So in a smaller practice where you don't have IT people, or you don't want to pay for it, just use OneDrive for Business. Set up files folders, subfolders, and then you get almost all the same benefits of SharePoint, which get it in a much less burdensome and easier to manage way. So I highly recommend that for smaller practices. Also with Office 365, we get tools like Skype for Business. This is ready for prime time, but people aren't using it a lot. It's going to be big in the future. It's like you can do gigantic conference calls in Skype for Business. You can share screens, and you can collaborate in real time on documents using Skype for Business. You can do, it's like GoToMeeting combined with conference calling, combined with a lot of other things. It's a great communication tool. The reason it's not getting a lot of use yet is you've got to have the right setup on your computer, the right, headset, and so forth. You've got to kind of get used to it. Within firms of any size, if you have, let's say, 5, 10, 15, 20 lawyers in your firm, I'd be using it internally all the time just to collaborate on documents, or if you have multiple offices. I'm using it internally all the time. It's a terrific tool. I've used it a ton in the American College of Real Estate Lawyers, where we're constantly collaborating on presentations and meetings and so forth. There are one big point about Office 365 is that Microsoft is taking all these pieces that are disparate and disconnected that we have in our practices, like word processing and presentations and email, and note-taking and task management and calendar management, and they're getting tighter and tighter and tighter. They're getting smarter and smarter about this. And they're going to help with productivity in the future in a way that you can hardly imagine now. One example is task. I have the good fortune of talking to the Microsoft colleagues quite a bit, and we've always complained about tasks, task management in the law office. And there's tasks that are in OneNote, there's tasks that are in Outlook, there's tasks that are in SharePoint. They're all over the place. None of them talk to each other. They're now close to releasing, and they have something called To Do also, which I hate because it doesn't work out. But they're very close to being able to drag and drop your emails directly into a task pane and an Outlook that will then centralize tasks from all over the Microsoft ecosystem, combine these tasks in email, because that's where your assignments come from these days, right? So you have a central repository of tasks, and then you can assign tasks to people right inside of Microsoft Word documents that also appear there and also appear in their task list. So that's coming and going to get better and better soon. So there's good things happening, and if you practice long enough, you'll be able to see all these things. So I also endorse those things that Mary was talking about in terms of automation. And Office 365 is going to get better and better at automation. There's already tools. This is one I'm pretty excited about inside Microsoft Word, where they're called clause libraries. They're clause libraries on steroids. There's a number of people working on this. There'll be some competitors in this area where while you're working in your document, you can open up your firm's clause library, and it'll show you for that area of law that you're working on, clauses that you may want to insert into that document in a hierarchy. And while when your competitor across the street sends you a wonderful document, you see a clause in there because you don't do plagiarism in a law business when you research, you grab that clause, you insert it into your clause library in the correct place in the hierarchy, and everybody in the firm now has access to that. So it doesn't automate everything the way that HotDocs does, but it's also a lot easier to use. So you could build a fairly complex document from scratch using tools of that kind. So you'll be seeing that soon, and I expect that to be big, very big for lawyers. So
On that, can you use tags to make sure that you have it marked as, this is plaintiff's side, this is, good for this.
Dave's asking, can you also tag these clauses so that, it's maybe plaintiff-oriented, buyer-oriented, seller-oriented?
Right.
Absolutely. And there's competitors. I mean, this is not Microsoft doing that piece, but you're going to see that in Word soon, available in Word. And some of the competitors absolutely have the ability to tag it. have the ability to show the origin of it, where it came from, who drafted it in the first instance. So that's the quick and dirty. Is there anything else in here that I marked as a biggie? So the fundamental problem with Office 365 is that it's sort of all things to all people. There is no special legal edition. It's not client matter oriented the way the lawyers are, so you've got to kind of throw that out yourself or design a system or structure as you do that will allow you to do that and track things in that way. We went to a lot of trouble in my office to build one out because exactly that. That may not be for everybody. So, do I have time? Any time questions? Or we done?
Yeah, you have a couple minutes. If anybody has any questions.
Everybody is thoroughly confused. Thank you very much.
We're going to take just a quick break. The sooner we come back, the sooner we can be done for the day. But if you want to grab some water, a cookie, or something in the back, and we'll start up here in the next 5-10 minutes. Thanks.
I can move up to this room. I'll just be over on the side. Thanks for mentioning my name. Other than my picture not being up there, which was inappropriate. It could have been better if he could have. Here he is. Okay, here he's gone. And I believe in technology. I believe in intelligence. Why else would you work with me?
Yeah.
believe it was a little tough road to get from.
Yeah.
I didn't know you, I forgot you were pretty late.
No, it's okay. No, I got it. Your voicemail? Yeah, no, I'm gonna talk. I think that's. Have you? I'm gonna ask you some questions. I hear that Koenig Dunne is very proficient in limited representation. Virginia has some recommendations. And basically, yeah.
He's fast. So when I want something super fast,
Let's see what's going on. Like a little different. It's like that's the email that I was frustrated. Not frustrated, but like, let's be done. So I just got to go back from him.
You got me wrong when you go.
Yeah.
And you go, oh, by the way, that day,
And he sent me a share. After I proposed that. And he's like, you don't need to respond. I'm fine. I just need to admit. One thing I'm like, it's like, so the first thing she said is, she proposes, she changes her mind all the time, we just gotta say yes, right? I'm just venting, I'm sorry. You guys are just total passive aggressive, whining, I can't respond to it. I feel like we're idiots for that.
no, that's what I would say.
Yeah. And that's what I was going to say to you, but I just
What's that? Yeah, whenever. Sit down early next year and knock one out. When I'm back at my house, my life comes very good. Probably next week. Start moving and then it'll be fun before it gets out of the after the wine tasting.
So they'll be with her anyways. Yeah. So Thursday's his birthday. Should we have the kids on Thursday? But yeah, so he must not have seen that. Because I said, yeah, I just forwarded him. It's the only email I got back. It's either going to happen or it's not. You want to get to the list? Remember now.
no.
No, I think I think these two things. Right.
And it seems as if, you know, she calls them someday versus
Every day.
yeah.
All right, I think we'll get back going. I moved the speaker over there because I realized, and I'm going to apologize to speakers already, I think it sounded like the speaker was in your brain because it was kind of behind you and echoing a little bit. So I think it's better for the people, the 18 people watching on Facebook right now, and people that are speaking, that they have a speaker over there. But next is Scott Hahn, and Scott is the chair of the Limited Scope Representation Subcommittee through the State Bar Association. And limited scope's been something that we've discussed for years as a bar association, and I consider it to be an innovative approach to building out a business, to helping people that can't afford necessarily a full scope representation. And so I wanted Scott to come here today and tell us about what it works well with, be honest, and what it doesn't work well with, and see if anybody maybe can take it back to their practice and build off of it. Scott?
Thank you, Dave. Very good, thank you. So I assume the right arrow is going to move me next to the next slide? Okay. Let me know if anybody is unable to hear me. If I'm unable to talk with the mic, or do I need the mic?
For online.
Okay,
Yeah.
I will talk with the mic. I'm Scott Hahn, and this is how to add LSR to your practice, limited scope. Can I see a show of hands of people who have done LSR practice at all in their regular practice? I see about 6 people, 6 folks. That is fantastic. Yeah, when Dave asked me to talk about this, this is a very practical way to add to your client base. provide an extra means of income to you, as well as to assist clients who are unable to pay for representation throughout the course of a case, as we know can become very expensive. But there are some rules and realities, hence the title. I am the speaker after the break, so wide eyes, everybody's up, ready to go, and here it is. So, limited scope representation in Nebraska, what is it? And basically, just to break it down for you, the client and the lawyer are selecting services that the lawyer will provide in a case. And then after reviewing the retainer agreement, signing an engagement letter, providing a copy of that to your client, you are then performing a discrete task, which means that you're not working on the entire case, right? And there are so many examples that we could talk about, and we will here shortly. But it's the process of taking on a client's legal matter, and you're trying just to break it down into tasks that the client is able to afford, and then you are able to take on for them. The client is paying for the specific task only, not anything else. You can base your payment and how you are paid by the client either on an hourly fee or flat fee basis. A lot of times, folks, it makes sense to charge flat fees. With limited scope, it helps to keep things kind of short and sweet with the client and simple, so they understand what is due and owing at the end of a case. And again, it's out without the large retainer that usually will turn a lot of clients off from retaining you as your attorney. One thing to remember in LSR, or limited scope, is that the client remains pro se throughout the process. So no matter the fact that you are assisting them with a task or a matter, the client is still representing themselves in the eyes of the court, and that's incredibly important later on in the case when you need to remove yourself or get out of the case. You don't have to withdraw because you were never their attorney as far as the court is concerned, the attorney of record in the first place, so you really aren't withdrawing when your representation is done. And then again, when the task is completed, the lawyer's work is done, and you are moving on, the client is representing themselves pro se for the remainder of the case. Limited scope, what is not in Nebraska or any other state as far as I'm aware of, it's not a second-class practice, okay? So whatever part of the case you've agreed to represent the client in, you are providing the same wonderful first-class practice as you are to any of your other clients who have paid a large retainer and are paying you throughout your case. All right? It's not unethical. You're not breaking any legal rules or court rules by taking the case on like this. In fact, most judges that I have found and have come across actually like LSR because they would rather have an attorney involved in a case for even a small percentage of it, a hearing, a motion, preparing pleadings versus nothing at all. We've all worked with the pro se party on the other side of the case, right? How fun is that? How many times have we gotten jammed up in a case and we can't proceed and the case won't move along until we get to trial because we just cannot talk to the other side about anything? And one other thing it's not just for attorneys who can't find clients for extended representation, which is to say that, you know, we could have a full client load of cases and still help clients out LSR because we want to help as many clients as we can. It doesn't mean that we're hard up for money. It just means that in some matters, clients are unable to afford us throughout the course of the case, and we are able to help them for a piece of it, and they are able to pay us for that. Here's some common examples of cases where LSR has been used. I talked to a couple attorneys right before the presentation today, and we were talking and saying, oh yeah, we've actually done that together, but we haven't really thought about it as limited scope, but that's exactly what it is. One of the most common things or places that this is used in is the preparing of pleadings or document drafting, preparing the initial complaint in a case, preparing an answer for a client, preparing the final pleadings in a case. Sometimes, and I've had this at my practice, We will have somebody walk in and say that the case is completely done, but all they need to do is just prepare all the final pleadings in a case, and they have everything done, and just need us to prepare the decree, the waivers of final hearing, whatever it is that their case involves. A settlement agreement, that's another area in which LSR is used a lot. Document review, a mediated parenting plan, for example. I've had a client once walk in and say, I just need you to look at this parenting plan. Is there anything missing? My soon-to-be ex-husband and I, we kind of sat down, did this on our own. We negotiated on our own. Before we submit it to the judge at trial, we just want to make sure it complies with the Parenting Act. Of course, it didn't. So there were things that I had to show to them, to point out to them, which was helpful, right? A prenup or a premarital agreement that you may have to review. I have reviewed a couple of those. They're kind of interesting, what folks want to limit the other side, what they're potentially entitled to once a divorce is entered. Didn't find anything strange or funny in any of the ones I've done, because attorneys worked on them prior to me looking at them. And you can also actually then enter a limited appearance in a case. And by entering a limited appearance, you are actually appearing in court representing a client for a particular part of the case. The common example that we see, I'm a family law attorney primarily at Hightower Reff, and one of the things that we see most is the temporary hearing stage of a case, where everything's been filed and they have a temporary hearing that is coming up, and they don't know how to draft an affidavit, they don't know how to make an argument on the record, they don't know how to serve the other side with the affidavits, they don't know, they've never appeared in a courtroom before, and so they need help with that. Obtaining a protection order. We have helped folks actually just prepare the pleadings necessary to get a protection order, to file for one, the petition, the affidavit, the order. We've actually also appeared at the hearing, and nothing more for them. A show cause proceeding, where we will actually prepare the pleadings for that and then just appear in court on the show cause, but nothing else involved. There could be a divorce going on, a custody action going on. There's some other things you can use it for, helping prepare exhibits for trial or discovery materials for trial. I haven't really done work like that. It's my opinion that when you get to the trial phase of a case, you really want to help a client throughout the course of trial as opposed to just a piece here and there. I have one client does come to mind, and the other side had a particularly aggressive attorney on it, and she actually held her own really well with this attorney. But she was also aggressive with me, which I didn't really like or appreciate too much, and so having to talk with her about how to prepare for trial was not very pleasant. I recommend that if you are working with someone and helping them prepare for trial, that you actually help them with the entire trial and not just a section of it or a piece of it. The Lsr Rules in Nebraska, as part of the Rules and Realities, they are the same as if you were representing somebody extended representation, right? They don't change. You still have to be a competent attorney. You still have to be a diligent attorney. You still have to talk to your client and communicate with your client. You have to be clear about your fees. They have to be in writing. They have to be clear of what those fees are, either an hourly rate or a flat fee. The confidentiality of information, attorney-client privilege, is applicable as it was in any other type of case. The conflict of interest rules are the same. Of course, the difference with things like the confidentiality of information and the conflict of interest rules is that they pertain only to the piece of the case in which you are assisting the client in, right? So if there are other parts of the case that you're not helping the client out with, or the other side wants to talk to you, or the other attorney wants to talk to you about another part of the case that you are not assisting the client with, those rules are not applicable. And then there's also rules about, working in a nonprofit and providing LSR, helping clients for free, pro bono service. This is a great way to get those hours that we're all supposed to provide to clients each year. And you're free to look at those in your spare time. The whole point of that slide is just to, once again, reinforce LSR is not a second-class practice. It's real, it's recognized in court, and you need to follow the rules. So, Obviously, one of the most important rules we're talking about limited scope representation is the rules about the scope of representation. And it is permitted under the rules. And one of the first rules that we have to look at is Rule 3-501.2, and sub B of that rule says that a lawyer can limit the scope of his or her representation of a client if it's reasonable in the lawyer's judgment under the circumstances, and the client has to give their informed consent to the representation. In some types of matters, as you would imagine, it's not reasonable to limit the representation you provide in a case. The most simple or easy example of that I could possibly give is in a case where you have a lot of complex financial transactions or issues involved. Is it really reasonable to limit your representation to a client to a piece of that case when what you do in that piece of the case is going to affect every other step or hearing involved in the case? Probably not. So some matters are more appropriate than others, for sure. The scope of representation continued. Obviously, it's not for all clients. Some of the things that a lawyer should consider when trying to figure out whether to use LSR in a case, the client has to have some degree of emotional detachment, a basic level of intelligence, which is not to be sarcastic, but it's true. A client really has to understand what is happening in a case, that you are just representing them in a certain piece of the case or a certain hearing, and not for the remainder of the case unless you agree to extend the representation. And they also have to be also motivated to remain in the case and remain involved. And then once your representation is done, you are no longer their attorney. And remember, they are still a pro se client for the remainder of the case. The importance of the interest at stake is also important. I would think, once again, getting back to the example of a case involving complex financial transactions, it may not be most appropriate or reasonable to use LSR in. Another thing to consider, most judges I have been in front of, in Douglas at least, in Douglas County, are very helpful in this process. They understand what LSR is. They understand what a limited entry of appearance is. They understand when you complete the representation and submit the certificate that the representation is over with. But will the judge actually explain that process to the client once you are done? And at the hearing where you submit your certificate and you say to the judge, may I be excused for the remainder of the case, Your Honor, and they say yes, they actually know what that means. Okay? So it wouldn't hurt in a case if you knew your judge well and actually approached the judge at some point and says, Your Honor, I'm just doing this for this piece of the case, LSR, the limited scope. I'm not representing the client past the temporary hearing, past the motion that I entered my appearance on. Does that judge understand that? More times than not, they do, and they're perfectly fine with it, but just make sure that they know up front that's what you're doing. And like we said in the past, or previously, it is always important to memorialize in writing what the scope of the representation is. If you could possibly imagine, clients love to misremember things, especially when it is what you promised you would do for them or help them out with. And you know what? If it's not in writing or it's not clear to them, I'll bet they say, I thought you were helping me out with getting after the temporary hearing, getting the order entered, or helping me with the discovery process afterwards, or helping me with mediation afterwards. If those things aren't in writing sometimes, which you are not helping the client out with, then you risk the client thinking there's an attorney-client relationship. And remember, it's important and it matters what is in the client's mind as to whether one exists or not, which is why it's always so important to have things in writing. The scope of the representation continued, this rule. The lawyer should always redefine the scope of the engagement between the lawyer and the client if the parties agree or understand that the original terms of the engagement no longer adequately represent what the engagement is now, okay? And if you don't watch out for that or aren't clear about that with folks, then you get into scope creep, all right? Has anybody heard that term before? We have a laugh in the front row. I assume this gentleman has. Scope creep is, oh, well, I helped you out with the temporary hearing, and you know, after the temporary hearing's over, we had a phone call and we started talking about the next step in your case, and didn't really enter a certificate that I completed representation in this case. Scope creep, you're probably now on the hook for helping them out with whatever you have now talked to them about, okay, until you complete the representation. So you should constantly memorialize in writing what you are doing for that client. The scope changes, folks, and a lot of times it's no longer appropriate to just represent a client in which you originally agreed to. Now you may need to represent them in something else, you know. In family law, especially, all my family law attorneys out there, things change constantly because we're dealing with clients' lives, their personal lives. Misunderstandings happen all the time. Make sure it's in writing, okay? Don't worry about tree killing. You know, in this type of case, it's fine to kill trees. It is perfectly okay because sometimes the more you have on paper, the easier it will be to conclude your representation at the end, to certify to the court representation is done and you are no longer representing this client. Because it is all about a meeting of the minds, and the meeting of the minds should be in writing, and then it's clear exactly what the meeting is. So, when you prepare pleadings for a client, you should just make sure and make clear when you do an LSR that you are saying prepared by and nothing more. Just saying prepared by at the bottom of the pleading in the lower left-hand side. The client is signing all of their pleadings. When you're preparing pleadings, they are also a pro se client. They are saying that next to their name, and they file everything. You do not walk things over to the clerk's office for them or e-file for them, because you know what? If you e-file, you have our number, that's going to show up in justice that you're the attorney of record for that client. Happened to me a couple of times, just because we filed. We didn't even think about it. We thought we were providing courtesy for the client. Yeah, we can e-file this. We can save the client a trip all the way down here from wherever they live down to the courthouse. Much easier on them. Now we're the attorney of record in the case, and we actually have to submit a motion to withdraw, which a judge would probably grant, but it's not 100%. They may or they may not. So they are the pro se. They're the party representing themselves. They are remain a pro se party, and you are just preparing the pleadings for them. The other thing that you are able to do with LSR is you are actually able to enter a limited appearance for a client who is otherwise unrepresented in a case. But when you do that, and there's forms available online, the Supreme Court's website has all these forms. Most of them just were updated this fall. It's a limited appearance, and it should clearly outline exactly what is your level of representation involved in the case. Okay? And now, the notice of appearance, of limited appearance, actually requires signatures of both the client and the party, which helps out a lot. The rules of pleading, this just kind of also says that, excuse me, this says that upon the conclusion of the representation, the limited representation, that you then have to certify to the court that you have completed representation in this case. A 10-day amount of time is provided to you to submit this to the court, and a copy is provided to the client, and the opposing attorney is the one, if there is one, or the opposing party. After such filing, you have no further obligation to represent the client at all. Your diligence requirements remain the same in LSR. Again, any doubt about whether an attorney-client relationship exists should be made clear in writing, so the client will not mistakenly suppose that you are looking after the client's affairs when the lawyer is no longer. And that just is another step you can take to submit a closing letter and a non-engagement agreement that you are no longer representing this client for the remainder of the case. Very important to do because, once again, clients love to misremember things, especially when it's free representation that you're helping them out with in a case. The communications requirement remains the same in LSR. You need to keep the client reasonably informed about the matter, promptly respond to written requests for information, inform the client of a decision that the court makes. Your fees, again, have to be sent to the client in writing or communicated in writing. I would say prior to even starting the representation, it should be part of your Your fee agreement, and there are examples of those online as well. The confidentiality of information remains the same. Again, just relating to the representation that you have agreed to help the client out with. If you're trying to talk to somebody that is already represented by an attorney, just make sure that you're talking to the attorney. If it's something they're helping the client out with LSR, if it is a part of the case that they're not represented in, you can talk one-on-one with the client. Realities, a general list of why attorneys should offer LSR in Nebraska. Clients like it, they're paying less, the courts like it because you're helping them out with at least a piece of the case. It provides more public access to legal help in a case. Legal aid is completely strapped, as are other services that provide assistance to clients for free of charge. And it also provides you an opportunity to expand your clientele base. If there are any other questions or concerns on the Supreme Court's website, there is a questions page to actually lay out a lot of the questions that are asked for folks who want to start practicing LSR. I advise you to look at it, and that was just updated as well. And those are the rules and realities of practicing LSR in Nebraska.
Thanks, Scott. Now I want to introduce Matt McKeever. And Matt was, when I told Donna Berkby, who runs the Lawyer for All service, who you saw in the back when you checked in, when I told her we're going to do innovation in law practice, she said, you need Matt McKeever to come talk about Bitcoin and cryptocurrency. And whenever Donna tells me to do something, I do it. And so you probably saw his recent article in the Nebraska Lawyer magazine. Anybody in the audience have Bitcoin? Okay, all right. Well, maybe after the presentation you will. Here you go, Matt. Yeah.
Thank you very much. Yeah, I'm Matt McKeever. I'm an attorney with Copple, Rockey, McKeever, and Schlecht. We have offices in Omaha and in Norfolk. And I'm here tasked with the job of trying to explain what a Bitcoin is in less than 20 minutes. So good luck. Let's see how this progresses anyway. And I'll field questions probably at the end of the presentation. So we'll be going at a good clip. I do have some slides. And just for some quick background, we've got the standard disclaimer, of course. Something else to keep in mind as we go along is that we'll be going at a good clip. If you want a copy of this PowerPoint, feel free to email me. I do have a handout at back too with some sample discovery questions, interrogatories and requests for production of documents that supplement this. You can also, of course, see the article in the Nebraska Lawyer that recently was published, and there are a lot of footnotes and research there. But today I just wanted to explain what is a Bitcoin exactly, what's a blockchain, and then 4 very quick issues related to those things. So there's the disclaimer. Read it. This kind of says it all right here. If you're talking about what is a Bitcoin, maybe you've heard about some bad things you associate it with criminal elements, and there certainly was that. But not as much anymore. What you'll find now is that there are millionaires walking amongst us who invested in Bitcoin. If you do any significant estate plan, maybe you run into some people trying to suddenly invest. They were formerly living in their parents' basement, and now they're living a lot better. Because you can see, July of 2013, we're talking about less than $1. 4 years later, it's $20,000 a coin. And there are people here in Lincoln, Omaha, who had thousands or hundreds of thousands of these coins. There are other digital currencies that went up at about the same time in July 2017. I worked with a development group on Blackcoin that used to trade for about 2 cents a coin back for a number of years, and then went up to $1.30 in some years. They dress a lot better now than they used to. So this gives you an idea why this might become a little bit more prevalent, that we'll start having clients and client-related issues involving Bitcoin. So what is a Bitcoin? I just want to get that out of the way. It's nothing so sophisticated. Most people in the news, they see the word Bitcoin, they blank out. They go, it's something strange, it's weird, I'm just not going to worry about it, no one's using it, so I don't care about it anyway. But people are using it because if you go to any Paycheck Advance or similar place here, they will sell you Bitcoin. And people are buying that and investing in it. There are Bitcoin ATMs in Lincoln and Omaha, for example. a number of other places that also have kiosks that will sell you Bitcoins or other currencies. So what is this thing? It's a shared digital ledger book. That's all it is. You don't need to be otherwise too concerned about the details. It's a ledger book that people share. They can make inputs on it, and it's secure. It's secured by cryptography. You don't actually get a physical coin out of the deal. You get an entry on this digital ledger book as how many units you have. You store those units on the ledger book. Your entry in the ledger book is called a wallet. And you can send Bitcoins or other currencies out of your wallet, and you can receive Bitcoin units into your wallet. And everything is secured by hashes. It's cryptography. It's a very complicated math puzzle. And you can release your funds only upon a very sophisticated key. Sometimes it's as much as a 64-bit encrypted key that no one can possibly break. So you use your key, you unlock your wallet, and you send units on the Bitcoin ledger book from your wallet to somebody else's. Really, that's all it is. It's digital cash. You don't need a middleman. You don't need a bank to clear a check. You don't need anyone. You can transact straight from you to someone else. So, for example, Ukrainian relief efforts, millions of dollars in Bitcoin were sent to the Ukrainian rebels. All they did was post a QR code for Bitcoin, and instantly, there was no waiting for the wire transfer to go through or anything. People coin, bam, done. So that's where the utility, the value of Bitcoin, how did it get to 20,000? There's a lot of speculation. But really, it has utility in that you can transact, you can send value to anyone on the planet instantly and securely. There's no central authority, there's no Fed, there's no one to complain to if you lost your Bitcoins, they're gone. It's somewhat unforgiving in that regard. There's no middleman, you're transacting directly between the two of you. There are miners who run the system, who run the software, but they don't control the transactions, they just make sure the program is running for everyone. It's trustless in that you don't necessarily need to trust the wallet, unlock your wallet, send the units, it happens. And it's not a fiat currency, of course. No sovereign government has said this is going to be the currency. Now, Bitcoin, again, it's a math puzzle. And so for the math puzzle holds together a block of transactions or series of transactions. There are thousands of transactions on the Bitcoin blockchain every 10 minutes. And so how that's organized is the blockchain organizes it into groups of transactions called blocks. And then the succession of those blocks is what's called the blockchain. And that's really all the sophistication involved. Everything is secured, like I said, by the math puzzle that is part of Bitcoin. So for a wallet, if you have a wallet, you get a private key and you get a public key. The private key you keep very confidential, you keep absolutely secret, because that allows someone to send your Bitcoins anywhere they want. So if you don't secure that, if someone hacks into your computer and gets your private key, they can send your Bitcoins anywhere they want. The Bitcoin blockchain, Bitcoin itself, is, for all practical purposes, impossible to hack. It's too powerful, the cryptography is too powerful, the computers running it are too powerful, but they can hack you, so you just have to maintain some security in that regard. Again, wallets are secure, 64-bit encryption, that's pretty good, and all the transactions on this ledger book are recorded from the very beginning of the Bitcoin blockchain in 2009 to right now. Every single transaction is recorded as one wallet address to another wallet address. And so if you're running the program, you have to download the record of all those transactions. So that's a description of what Bitcoin is generally. So what's blockchain? You probably hear those in the same context. Bitcoin advocates have been talking about more blockchain because there's a stigma on the word Bitcoin. I think you're criminal, so they're calling it blockchain. Bitcoin was the first blockchain. It's a new technology that just combines three very old and existing technologies. A digital ledger book, which we've all seen, maybe even Excel as a ledger book anymore. Network computers, that's been around since the 1970s, and cryptography, that's been around since Roman times. So you combine them together and you get something that's secured by mathematics, can transmit value anywhere on the planet instantly. Here's what I'm going to try to do as an attempt. I've been using the same diagram for about 5 years since I started doing presentations on Bitcoin. So we'll give this a shot. I even have a laser pointer, which should help. We got two people on a ledger. We've got Alice and Bob. Alice wants to transmit units to Bob on this blockchain. Again, just a ledger book, but that's all it is. She uses her private key and sends 1.005 units on this ledger to Bob. And so she has no units, no bitcoins. Bob gets all those units in addition to the 1/10 of the bitcoin he already had. So there you go, that's a transaction, Alice and Bob. Well, let's substitute Alice and Bob for a wallet address, which is a series of letters and numbers. Still the same people, but they're somewhat synonymous. They're not anonymous completely. They're using a pseudonym in the way of this address. So if you're dealing with Bitcoin, you'll see these kind of addresses. If, let's say, you're doing some discovery and divorce, and you see something like this, that's a wallet address. So same transaction, Alice, using this wallet address, is using her private key to transmit the Bitcoins to Bob's address. And so that's a transaction on the Bitcoin blockchain. That's all it is. Numbers changing around. So here's a block that I was talking about. Private keys, different people. Now we've got all sorts of people transacting and sending on the Bitcoin blockchain, and a lot of different people receiving using their addresses. Again, it's a pseudonym. It's not completely anonymous, because you know what? FBI or other institutions that have sophisticated algorithms almost all the time can find out who these people are without even doing some legwork, without even interviewing people. They can use computer software to really find out who's who on the blockchain if they have to. Not all the time, but nearly all the time. So here's a block of transactions. Let's say this was a 10-minute interval on Bitcoin blockchain. Now, every 10 minutes or so, the mathematical puzzle that Bitcoin presents is solved by one of the thousands of computers running the program. And that creates a new block. All these blocks are now secured and they're transmitted for approval onto the Bitcoin blockchain. And so what we finally have are a chain of blocks every 10 minutes or so. Here's a block of transactions, and then the next successive one, against they're secured by the math puzzle. So they're all linked together, and they all relate to changes that are on the ledger book. So that's why we call it a blockchain. It's a chain of blocks, a chain of groups of transactions in a ledger book. There you go. Oops. Some fanfare there. We're going to describe Bitcoin in less than 5 minutes. So there you go. I didn't even have to show all the cartoons that I have about it. I didn't have much time. So I spared you all the Family Circus and Wizard of Id cartoons that I had going along with this. You can thank me later. So there are now thousands of blockchains. Bitcoin was just one. That's the first one we heard of. It's the biggest one. If we're talking about financial software, there are thousands of them. Some of them have roots here in Nebraska. Some do, of course, are all over. There's Litecoin, there's Bitcoin Cash. Bitcoin is publicly accessible. You can go on to GitHub, a website, and download the Bitcoin software. It's not a secret, it's shareware. And you can start running the program if you want to. You can also make alterations to the program. And if other people run the program, you can have your own coin if you want. And that's what Bitcoin Cash is, and a lot of these are almost exact copies of Bitcoin with a few tweaks. So some of them have different features, like Blackcoin. You don't need miners. Just the more you have, the more coins you're rewarded with. And this one is a ledger book that deals with power generation, for example. And of course, everyone's favorite Bitcoin variant is called Dogecoin. It's a coin completely based on Japanese shied dogs. And don't ask me why. There's no reason to it. It's primarily a coin that's used for charitable donations and charitable causes. So there are thousands of these. Now what about blockchain itself? Now you can do it. You don't need to use it for transactions. You're seeing places like First National Bank of Omaha and Mutual of Omaha, here in the Nebraska area, and other industries popping up, not based on coins, but on the underlying technology itself. We have logistics and quality control. For example, you can track diamonds from their source to present. You can track bushels of corn from the field to the final producer. You can track each individual apple, if you want to, on a blockchain, where everyone has, it's a shared ledger book. Everyone shares the ledger book and makes inputs as you go. You can secure information. It's encrypted. There's almost no way to hack the blockchain. You only have 5 attempts, and you've got a 64-digit number you need to guess. You're not going to guess that number. You're not going to hack it. So records, especially medical records, could be stored securely. Accounting, would be very helpful. All transactions, for example, on a blockchain are automatically tracked. So we could have participants in the same industry sharing an accounting book, for example. Copyrights, Embermine and Inc. are the names of two companies here in the Nebraska area that work with blockchain and help with copyrights. And I mentioned First National Bank. R3 is a consortium of banks, international banks, that use, instead of wire transfers, they use a blockchain. So it's getting ubiquitous. So we have about 7 minutes left. I'm going to go into a couple of issues that you might run into. Now that we've kind of described Bitcoin and blockchain, what issues are you going to run into? So I have 4. The first one is your client says, I just sold my buddy a whole bunch of Bitcoins. It's like, great. Well, you're probably an unlicensed money transmitter subject to criminal laws both on a federal and state level. So there you go. But possibly they're not. But if they need to, they first need to know Bitcoin is legal to buy and sell. You can do that. If you're a merchant, you don't need to license with anywhere to receive it for payment. There is a central authority. Mark Quandl, the director of banking and finance for Nebraska, last week at a Rotary Club meeting I attended, said Bitcoin is unregulated. To some extent, that's true. In Nebraska, we don't have specific laws talking about digital currencies. But on a federal level, FinCEN does require you, if you're going to sell Bitcoins or other currencies, you need to do know your client, KYC, you need to do anti-money laundering, and you need to potentially report to the Treasury Department. 48 states have different money transmitter laws. Some apply, some don't. Nebraska has a Money Transmitters Act, of course. And does it apply, though? If you sell Bitcoins to a friend, or if you have a Bitcoin operation that sells Bitcoins, are you a licensed money transmitter? In a lot of states, especially like New York, you definitely are. Nebraska, not so sure, because Nebraska has the exact same act, the model act that Kansas had. Kansas came out and said, cryptocurrencies aren't really money. So you're not transmitting money or monetary value, so you don't have to license as a money transmitter, which is great because that's thousands and thousands of dollars of cost, and a startup company dealing with these coins, it would be prohibitive. We wouldn't see technological development on the Silicon Prairie if we had that. Now, Nebraska has been considering laws to regulate Bitcoin and its variants, and 4 of those laws popped up last year, and I'm sure they'll pop up again. And basically, these deal with laws very similar to a model act in the New York, what's called bit license. And that bit license caused nearly every business in New York that dealt with Bitcoins to be called the Great Bitcoin Exodus. But basically, it's applying money transmission and anti-money laundering regulation along with a lot of regulatory overhead both at the state and in the company itself, just in order to do work with Bitcoin. So we'll see. I'm sure some or all of these bills will pop up again next session. 2, hi, I'm your client. I just sold a whole bunch of Bitcoins. Do I have to pay taxes? I sold them 3 years ago. Should I pay tax? Yeah, you totally should have paid taxes on those. If you made money. Now, if you didn't make money on Bitcoin the last 4 years, you probably weren't doing it right. So for the most part, your clients are going to have some tax issues. Basically, long and short, it's taxed as a capital asset. It's not currency, so if you were selling dollars for dollars, you're not going to have a capital gain. Here you do have capital gains that have a basis of a fair market value when you got them. Mining, if you're helping the Bitcoin blockchain and you get Bitcoins for doing that, that's seen as income. And anytime, it's like any other capital asset, you have the asset, you convert it to dollars, that's your taxable event. So again, realization of gains is what we're looking at. Now, for the most part, theoretically, if someone goes into, like, Jones Brothers Cupcakes here in Omaha, you can buy cupcakes with Bitcoins there. Every time you do that, is there a taxable gain? Yeah, there might be a taxable gain. It's almost impossible to track all these transactions. So for the most part, you've got to be careful. If you have anything significant, someone needs to record it, talk to their accountant. But for the most part, if they're transacting on a digital exchange or even their own wallet, the software might keep track of their gains for them. And so hopefully that will help. But basically, taxpayers have to self-report. No one is reporting these gains and losses anywhere. And again, we're talking about long-term and short-term gains apply. So if they hold on to their Bitcoins for a year or more, they're talking about long-term cap gains. And there's a substantial savings there in taxes. So, wash sale rules apply, if you're familiar with accounting. And like-kind 1031 exchanges, a lot of people have tried. They've sold to the RRS their song and dance about how if they bought one coin and traded for another, it's exactly the same. No, the IRS said, no, you can't do that. That's two different, that's a transaction and it was a taxable event. So no like-kind 1031 exchanges. So that's the tax issues in a nutshell. How about if your client's spouse hiding assets? You have a judgment debtor that bought some bitcoins. What do you do to go after those? Do some forensics. You kind of have to, but anyway, it's usually more than a debtor exam. You get their computer, you get their phone, you get that expert to look at the phone. What are they looking for? You're looking for wallet software and exchanges. You might not be an expert for that. Off their computer, they might have records from a paycheck advance here in the neighborhood or a Bitcoin ATM. At the bank, look at their incoming wire transfers. Did they get a wire transfer from the Bitstamp exchange in London? That's a dead giveaway. They're doing some work on the exchange. They probably have some Bitcoins. And wallet software on their phone or computer. That might have some exchange information. Exchanges are places all over the world where you can buy and sell Bitcoins, and that information might be on their phone. So for discovery, here are some basic things that you might ask if you're trying to find out, first of all, if someone has Bitcoins, and so what happened to them. I've had, my firm anyway, has had 2 divorces in the past 3 months where this has popped up. As people are going to those cash advance places, they heard about the hype, they bought some Bitcoins, and guess what? If they only know where the software is and their wallet is, they might not report that. So how else are we going to find that? It might be a significant amount. I have those in writing. I gave those to also Mr. Summers for distribution in electronic form. I have about 60 copies of sample discovery demands in back there. And so take a look at electronically stored information, ask about transaction information, ask if they reported to any tax authority. I've got to wrap up here. So can your client pay you with digital currencies? Nebraska is the only state in the union, the only sovereign entity in the country where their bar association come out and said, yes, you can, and under what circumstances. This was an opinion issued last year. Basically, if you accept digital currencies, you need to immediately convert them to US dollars. You can hold them in trust for clients too. Under certain circumstances, you need to undergo security and have reasonable security measures to keep them, but otherwise you can't. Here's the ethics advisory opinion for lawyers. It basically says you can accept property generally, of course. This came out last year. You have to be sure that the fee remains reasonable according to our code of conduct, of course. Volatility creates that unconscionability. Someone pays you in Bitcoin, next week they just paid you 3 times the values of your services. So you have to convert. And I was of the school, I helped submit and draft the advisory opinion, and I'm still of the opinion, unlike some others, that you do have to convert it to dollars. You can't credit the client's account the fair market value at the time. It's just still not fair. The value might go up radically, and then you exceed the profit. Of course, we need to put our interests behind our subjects are subject to the best interests of our clients. So, and the best way to find out what the fair market value anyway is to actually sell it for fair market value. So there might be some other advocates in the Bitcoin community that oppose that, but that's our opinion here in Nebraska. If you wanted to accept fees, it's very easy. You'd be surprised how intuitive it is. Go to a major payment processor. These companies do billions of dollars in transactions a year using Bitcoin and other currencies. And a lot of them don't charge a fee because they're also wholesalers. And so they don't need to charge a fee. They need the liquidity. So they'll take your Bitcoins, give you dollars, and they won't charge you a fee for the first $1 million, for example. A little counterintuitive, but that's the way it is. All you need is a paywall button. Your client clicks that. They scan their QR code from their wallet. They transmit. You're paid. No chargebacks. That's great, isn't it? No fees or very little fees. You're not paying the credit card company 35% for the transaction. So 4 quick issues. And I don't know that I have any more time for questions, but I'll be available after the seminar today. So thank you as we went through a very quick tour of Bitcoin and blockchain. Thank you.
Last but certainly not least, if you've been to this CLE in the past, you've heard from and you've seen Susan Koenig. She's our closer. We love bringing her at the end to give us a little bit of perspective, stand back, and try to figure out how we're going to manage our day-to-day use of all this new innovative technology and everything like that. And so she didn't have a slide. She's our only presenter today that didn't have a slide, so I made a slide for her. But without further ado, I'll turn it over to Susan Koenig.
Thank you, Dave. Great to be with you. So I am a little bit old school, and in a minute, Scott Hahn is going to give you a half sheet of paper, and you're going to need 3 things in a little bit. A pen, that piece of paper if you're at home watching this or in your office watching this, some other plain piece of paper, and it'll be I'll be the one speaker of the day who says it's okay to really have your phone out and use it. So, because you'll be using your stopwatch, but hold on, not quite yet. I want to talk to you today about your email, but really I want to talk to you about lowering your anxiety and increasing your efficiency during your days. Because every day I talk to lawyers who say to me, I've been here all day long, I put in my 8 hours or my 10 hours and my 12 hours, and where did it go? They're exhausted, they're stressed out, and they haven't accomplished all that they had hoped to in the course of the day. So I'm going to give you a couple of tips around managing your email, but really I want you to leave here today with some insight about how you're using your days, how you're using your time, your energy, and what it's costing you. Because I would love nothing more than for the lives of people who are watching this, the lawyers who are listening to this, to have their lives be easier. So I'd like to see a show of hands. How many of you put on your out-of-office reply because you were going to be here this afternoon? Can I see a show of hands? Really, hands up if you put on your okay. Patrick, why did you put on your out-of-office reply? And I'll repeat it for those of you who are listening outside of this room.
To really, as a client service, to know that I'm not available.
So for client service and your clients to know you're not available.
Yeah, and it allows me to be here now.
And you can be here now because you're not worried, thinking about the clients who are emailing you, and you're not on your phone, you're 100% present to what's happening here today. Yeah, what does that get you?
I'm not in the back of my mind wasting that energy on trying to make things at once.
You're not in the back of your mind wasting your energy trying to do 2 things at once. Great. So this is a tool, simple tool, you've all got it. What happens when we don't have our out-of-the-office reply on? Every client who emails us wants to know why you have been gone all afternoon and have not responded to their email. Or, if you are responding to their email within minutes or an hour, what's happening? What's happening to the client expectation? The client is expecting that you're always going to be answering immediately. Now, I know we all have different clients with different expectations, but a lot of us have clients who would be very satisfied if their expectations were met, whether we were answering their email in 20 minutes or in 20 hours. When you are constantly responding immediately to your email, you are creating an expectation with your clients that they will be responded to immediately. Now that is fabulous if you can do that all week long. But I don't know about you, I've got shifting priorities every day in my life. And sometimes there is something happening in my world that is more urgent and more important than responding to that email. But if your email is your default and the place that you go to as soon as you have finished the next thing on your to-do list, you are not setting your priorities. Whoever happened to email you last is. So I really want you to begin shifting your thinking about the frequency of the checking of your email. So I'm going to ask, because it's end of day and Dave lets me do this, I'm going to ask everyone to stand up for just a minute, if you wouldn't mind. I promise you I'm not going to have, I know everyone gets nervous when it's a coach in the front of the room, like it's just going to get all touchy-feely, I'm going to have to talk to my neighbor and all that. I promise nothing bad is going to happen here. But so let me just see, let me ask you some questions. If you check your email fewer than 4 times a day, 4 times a day or less, 4 times a day or less, you're going into your email and checking, would you have a seat? Well, I see one person sat down. All right. If you are checking your email fewer than 6 to 12 times a day, okay, think about that. Fewer than 6 or 12 times a day, would you have a seat? So, all of the rest of you who are standing up, please have a seat unless you're someone who keeps your email open all day long and you're, like checking it all the time. So, all right. Dan, you and I are going to have a talk later. I can't wait for Mr. Technology to have a conversation with me about checking his email all day long. Okay, please have a seat. Okay. Just wanted to see where we were in terms of how many times we're going in and out of that checking of your email all day long. So, how many of you have a notification either by sound or a pop-up for incoming email? Can I see a show of hands? Okay, all right, so if that is you, I'd like you to have a conversation with someone else in this room who does not have that regarding why you want to, first thing Monday morning, because I'm sure none of you are working on the weekend, right? Yeah, next time you are in your email, to turn off that sound notification or that pop-up. I'm going to say that again. I want you to talk to someone and say, why do you have it off? Because I promise you it is costing you. It is costing you time, energy, distraction, because you know how it is. You're working away on that document, and then it comes up, ding, and you just glance over, oh, it's not important, and you go back, right? And you do that all day long. All day long. The increasing anxiety that lawyers have and other people who are working all day at a desk on a computer where email is incoming is extraordinary in large part because of the inability to have sustained focus. It's very difficult to go deep and stay there in your thoughts and in your work when you are constantly being drawn somewhere else. So in a moment, we're going to do an exercise to help us look at this. But if you have a pop-up notification or sound notification, if that's the only thing you took away from today, and you made that change, I promise it's going to improve the quality of your life. How many of you are using some sort of software right now, something like Simplify, to help organize your email into folders? Raise your hand if you do. Raise them a little bit higher just so I can really see. Okay, so maybe a third of the room. For $50 a year, okay, $50 a year, you can use Simplify. I'm sure there are others too. This is the one we have to use at Koenig Dunne to get your email quickly, one click, organized into the folder that it belongs in. One click. It uses an artificial intelligence algorithm that will become more intelligent with use, so that rather than you scrolling over, dragging it, with a click, you're getting it right where it belongs. Does this interest you? With the volume of email that you get. And maybe some of you don't have practices where there's a lot of email, but I will tell you, there's nothing like being able to go right to the folder to get right what you need from the last person, the last email that you needed. And to be able to do that efficiently and easily. And this is nothing sophisticated. believe you me, I'm a late adopter to all technology, but this is something that's crucial to making my days flow with ease. So you can go to, let me give you the website, it's techhit.com if you want to check out that particular tool. So for a lot of us, just cleaning out our email inboxes is something that is difficult to find time to do, and it just gets worse and worse over time. What's the solution? Make some time for it. How do you make that time? Like you make time for everything else, you put it on your calendar. You know the time of the day or week or month or year when your energy is low, and you, not like right now, like you're all really fired up here to be here today, I know, but you know what I'm talking about. When you'd love to just have something really easy to do because your brain is worn out and you're not ready maybe to leave the office, you'd like to be productive, but you're a little pooped. What can you do? You can schedule in advance your tech purge time, where you plan in advance to do this. Because listen, it's always going to be a lower priority, which is why it never happens. It'll only be a priority if you make it that, get it on your calendar. So put it on your calendar at a time that really makes sense for you. So here I've given you some little tips, but what I really want you to look at is that frequency of going in and out of an email. We think of this as multitasking, right? We think we're doing more than one thing at a time. We're following our email and we're drafting a document. We're talking to the person who came into our office and we're looking at our email. Not so. It's really switch tasking. This is a principle from a book by Dan Crenshaw called the Myth of Multitasking, where he helps us to understand that we're not doing two things at once. We're going from one thing to another, back again, with a whole lot of steps in between. So what I want you to look at is, now not background multitasking, like you're listening to music and you're folding your laundry, where it's not taking mental energy to do one of the tasks. But I'm talking about things like texting and driving, right? Talking to a family member while you're on your computer. Those are really, you're going in between, you're not really being present to either one. So we're going to look at how well this notion of switch tasking, going in and out of a task, really works for us. So Scott Hahn is going to help me out here. If you don't, do you all have your little piece of paper? Scott, everyone's got their little sheet of paper. So if you're watching this now, old school pen and your stopwatch on your phone, if you have a phone with a stopwatch. So if you are at home or out of the room, if you would write this sentence, multitasking is worse than a lie, at the top of your page. And for those of you who have a piece of paper, it's already written out there for you, so it's right there for you. Multitasking is worse than a lie. So in a moment, you are going to write out that sentence one letter at a time in a moment, and I'll let you know when to begin. Now, when I say I'll let you know when to begin, what happens to all the competitors in the room is they start gearing up, like, can I start in advance? So this is just for you. No one will be comparing scores. This is not a competition, so all is well. But when you write it, you're going to do one letter at a time, and after each letter, below it, you're going to write a number. So when you write the first letter, M, you'll write a 1. I've started it there for you on the piece of paper. When you write the second letter, U, below it, you'll write 2. When you write L, then below it, you'll write 3. Everyone get how this goes? Questions? Am I clear about what we're going to do? So that when you're complete, you will have written M1, U2, until you've completed this sentence. So we're going to time ourselves on this exercise. So in a moment, I'll say you may begin, and you'll hit your start on your stopwatch, and you can begin. So I'll give you a moment to get underway. Pull out your phones, set your stopwatch, and you may begin. All right, so if you'd note your time, just for yourself there, how long that took you. Now, we're going to have you write that sentence again, letter by letter, only this time, and we'll be timing it as well, this time you're going to write out the sentence one letter at a time, and then you're going to write the numbers 1 through 27 straight across. Does that make sense? So you're going to copy that again, but this time the full sentence and all the numbers. So set your stopwatch, or your timer rather, you may begin. So, note your time if you didn't already. So, what did you notice about the first time in contrast to the second time? Let me hear from you. It took twice as long. What else? It was sloppier. It took twice as long. It was sloppier.
It was harder. Harder.
It was harder.
More stressful.
It was more stressful.
And I made a mistake.
And I made a mistake. Take that in for a moment. It took twice as long. It was sloppier. I made a mistake. It was harder. It was more stressful. This was a really easy exercise that took about 3 minutes, and notice how you experienced your focus, your concentration, your clarity, your ease when going in and out of even a simple task like writing down a single letter or a single number. Now imagine that you're going in and out of a contract, in and out of an email to a client, in and out of trying to think through a complex legal challenge that you're just trying to come up with some creative solution for. We think that we're going from one task to the other and back again in an instant. Not so. It's about 10 steps in between. And they look like this. Step number 1, you're interrupted. Like you're going from wherever you were to seeing the pop-up or seeing that that email has arrived. Number 2, you leave what you are doing to get there, right? Number 3, you look at that interruption. Like you look at it. You know, is this important? Who's it from? Does it have the notification that it's urgent, right? Number 4, you make a decision about it. I'm going to open the email. I'm not going to open the email. I'm going to open the email later. I'm going to delete it. But you make a decision. You go through the thought process of making the decision. And then you finish that interruption. Even if the finishing is like, I delete it, I'm done in an instant. Then, by now, you're at step number 6. Of course, you're going to repeat those steps 1 through 5. If it sits there and you don't do anything, you're going to go back and do all of those all over again next time. But step number 6, you remember, you try to remember, where was I? What was I doing? And then step number 7, after you've remembered what you're doing, is you find what you were doing. Which of the 5 documents that I have open on my screen was I working on? And you find it, right? And then step number 7 is you look it over to review where you were in that. Like where was I in the editing? What paragraph was I on? And then you get yourself back into the mindset. Okay, step number 9, like I'm ready to work on it again. And then you start back up again, step number 10. Now all of these steps may happen in a matter of seconds, but what you think is a single interruption isn't. And you are using your energy in these micro moments every time you're doing that. And your focus is diminished just a little bit. Except that if you are doing this dozens of times in the course of your day, you wonder why you're just a little unsettled, or why you don't feel accomplished, or why it is taking you so long to get things done. You look at your time on your computer and you see, oh my God, it's been 40 minutes and I've only gotten through 1 paragraph. What happened? Right? So this is why I invite you to think about how you want to be looking at your email, how often you really want to be checking it. Now, for those of you who are using your email as the default place to go to when you have finished a task, I'm going to suggest that you have some other place to go to focus your attention when you're finished with a task. Because you know, that email is just it's like the easy place to go look. Okay, I finished that phone call. Okay, let's see what's on my email. I finished that document, I'll go check my email. I reviewed that draft, I'll go check my email. I talked to my paralegal, I'll go check my email. And all day long, the incoming email is driving your priorities, your agenda. And then at the end of the day, you haven't got that most important thing done and you're wondering why, but now it's 6 o'clock. So, you know, there are other options for the default, like your priority to-do list for the day. What would it be like to have your priorities that you planned in advance drive what you were going to be doing next, rather than that comfortable spot of going back to the email and back to the email? Now, for a lot of us, you know, we've developed these habits over a long time, and we're not going to change them easily. But how we create new habits is by giving some rewards for the new behavior. And what I promise you is, if you begin having your priority to-do list be the place where you focus your attention rather than the next incoming email, then you're going to get the reward of satisfaction, accomplishment of your, whether it's your billable hours or really attending to the clients who have the most urgent priority matters in front of you. So no matter where you are, I'm going to encourage you to start. Start where you are. You know, pick one thing that you took from these few minutes that we have together here today and say, I'm going to do that. I'm going to get Simplifile, and I'm going to start organizing my email with more efficiency. I'm going to turn off that notification. I'm going to, instead of having my email open all day long, maybe I'll only check it once an hour or, 4 times a day. But wherever you are, start small. Start small so that it's sustainable. And then over time you can add more skills till you have your days back in your control. I'd encourage you to seek some support. Does anybody here in the room have someone else who's in their firm or their office who is managing their email for them? Let me see a show of hands. Well, that explains why you're not worried about how often your email is being checked if someone else is managing it for you. Brilliant. If you can do that, that's your ideal, right? Someone else who's reducing the amount of time that you're spending so that your time is really spent. And start making your lives easier. So, thank you for letting me be with you today.
With that, we're 5 minutes early. Make sure you sign in at the back for credits. Let us know what you liked, and we'll do more of in the future. And if you need the documents, they're online under the CLE tab on the Omaha Bar Association website. Thank you, everybody. Thanks for watching online.